Good morning again to everybody. We are now before the tribunal, and Mr. Pelé in particular, asks questions to the parties. Are there any housekeeping issues that we need to deal with?
Sí los hay, señor presidente. Y creo que es por un tema de buen orden.
Yes, there is one, and I think it's a matter of order. Whenever you're ready. According to Article 1810 of Procedural Order 1, which the tribunal reminded us of yesterday, there is a rule for the sequestering of witness or sequestration of witnesses, with the exception that the representatives or the counsel of the parties can be in the hearing room only to hear the opening statements. And that has already happened. So with all due respect, we put to your consideration that Mr. Finley and Mr. Kernion would perhaps leave this hearing room because they are witnesses. And of course, they should not be listening to the testimony of other persons. And another important element, they should not be hearing the questions and the answers from the tribunal and the answers from the parties. So I would like to put this to your consideration. A couple of matters. First, if we could better define today's agenda. If we finish earlier, then maybe we can have this round of questions that the tribunal wants to have, but perhaps we can start with the testimony of Mr. Finley, as the agenda establishes, and then as witnesses finish, we can add more people. Yesterday, Mr. Finley and Mr. Carey were not here, but I think we've been very reasonable.
Statement by the respondent.
Could you please repeat what you said? There was still interpretation going, sir.
No, I give the floor to the claimants.
Sorry, I was catching up. The hearing started while I was in the restroom. If I understand correctly, Mexico wants Mr. Finley and Mr. Kernion to leave while we finish our question and answer session?
Yes, or for those questions to be postponed until the end, once the testimonies have taken place.
I'm not sure that's the protocol we followed before, and I'm not sure why there's a concern on that. They're the party representatives. We went through that day one about party representatives. I have no problem with them not being in the room while the other testifies. That was always the plan. That's the protocol that we followed. I don't see the concern. They chose, the government of Mexico chose its victims here. They need to live with it.
Señor presidente, voy a hacer un comentario. Esta no es la
I have to make a comment, Mr. President. This is not the first time that the representatives of the claimants, not only do they make incendiary comments, but they're also inappropriate comments, lacking in good manners in how you address a tribunal and a respondent in an investment arbitration. That's point number one. It's very important to make that clear in the transcript of today's session. Point number two, let's go back in time to 2023 to our first hearing. All investment arbitrations, at least the ones in this institution, follow that rule of sequestration. There might be a representative of a party during the opening statements, but if that representative is also a witness, that person must leave. And once he has given his testimony, then he can stay for the rest of the session. We've gone through this before, and I find it strange that there is no memory of paragraph 1810 of procedural order number 1. We don't want to turn this into an argument, but this is the case.
Could you refresh us about paragraph 18.2?
18.8, I think. Okay, so, sorry, 18.10 of procedural order number 1. Witnesses shall not be allowed in the hearing room before rendering their testimony except for witnesses who are also party representatives who may attend opening statements. Experts shall be allowed in the hearing room at any time. Witnesses who are also party representatives shall render their testimony as early as possible in the course of the hearing.
Okay, so the question is whether opening statements include questions on opening statements. That's essentially for the tribunal to decide. Shall we?
Happy to withdraw quickly.
Hmm?
We're happy to withdraw quickly.
We have,
I'd be happy to withdraw quickly to deliberate, but I
Yes,
have
okay.
a clear view.
shall we go? Yes, 30 seconds. Well, without this setting any precedent, the tribunal has accepted Mexico's objection, and so Mr. Finley and Mr. Kerleon will miss the questions from Mr. Pelé. So if you don't mind to leave being sequestered for a while until you come back to testify in turn. Any other issue?
No, señor presidente, gracias.
No, Mr. President, thank you very much.
So, Alain, the floor is yours.
Thank you. I'm sure they will miss a lot because as
Sorry, Mr. Finley, just a second.
as a reminder, my questions are rather short ones. You may answer at length if you want, but it's more to give you a direction of my own question in my own head. And they are a bit naughty in any kind of order. Well, first, and this for me is rather intriguing. What is an open contract?
There's a law in Mexico that describes an open contract as either one of two things. Something open in the terms of the quantity of work or the amount of work. And it says if you do either or, it's going to be 40% minimum to whatever the maximum that's set in that contract.
And this is legal. It's a law. It's an act in Parliament. It's a decree. What is that?
It is.
I don't remember having read that, but probably I missed it.
It is a law, and I'll tell you when to be candid, I stumbled upon it, and I asked one of my colleagues in Mexico who does oil and gas, and I asked him, point me where I can find something defining open contract. And he said, well, you're not going to find it in the Pemex law. So I agree with Mexico when it comes to that. He said, however, as Mexico probably knows, everyone was using a certain law up until the Pemex law. And so government, I don't want to call them bureaucrats, functionaries, entities within the government used a certain law to do their procurement, to do their contracting. And it's called, I think, the law of acquisitions. I think it's in the materials. I know it's in the materials. And he said if he were sitting in the room when Pemex was designing these contracts and using the term open contract, this is what they had been familiar with doing throughout their history up until the Pemex law, and this is probably the concept that they had in mind when they were contracting. So that's the history of the open contract.
So it's special to Pemex, apparently?
No, it's special to all the government entities in the Mexican government.
Okay, thank you. Well, please don't be scared if I don't take notes. I never do because I prefer reading than trying to read myself.
Gracias, señor profesor Pelé.
Thank you, Professor Pelé. Just an observation. We can hear from the answer given by the claimant's representative information that is hearsay. Somebody informed him that, in his view, an open contract is this. I don't think that's a real answer, and I want to make that very clear, because hearsay is not information that I think should have a lot of validity, but I'm sure the parties will be elaborating more on this topic in our post-hearing submissions and when we've analyzed your question more deeply. Then Contract 821 was not subject to the law mentioned by counsel of the respondent. It is not subject to what is known in Mexico as the acquisitions or procurement law. Actually, Contract 821 was governed by the Pemex law that was applicable at the time, and especially also it was based on certain administrative provisions that are colloquially known as the DACs. And that's very important for you and the tribunal to have that on your radar. Now, in terms of your question, an open contract can be considered to be one that has a maximum or minimum budget, or also a maximum and minimum in terms of work performed. So these are sort of ranges. It can be both. I'll stop here in case my colleagues from the Mexican delegation have anything to add. But there is a significant point here. They are not subject to the acquisitions or procurement law that the counsel for the claimants was referring to. I see that my colleagues have nothing to add at this time.
So, thank you very much. I think it can be useful. Another, a bit also general question. Sometimes I think Mr. Porter and somebody else, you spoke rather quickly on punitive interest. I think that you said that they were not authorized. But what in this case would you would consider? The question is for both parties. What in this case do you consider as possible interest, or interest which you need to say, oh no, they are not punitive, but after all, we would like that they be decided by the tribunal, and we want to make sure that it's not punitive. Because, sorry, I can be very transparent on that, because I think that punitive interests are clearly not at a possible outcome in investment or more globally international law.
If I may, I think it's our position that any award, any amount that awards claimants money above what their losses are established to be is punitive. So if claimants are awarded $41 million for a bond that they do not ever pay, that's punitive.
I must say, if I ask a question, it is because I don't see any reason to to give more reparation above the losses. This is why I ask the question. I find your defensive position a bit curious, because for me there is no question that punitive interests are outside the international law of responsibility. I was a member of the ILC for 22 years, International Commission for 22 years, and this took us days and days of discussion. But well, okay, I wanted to be clear. I think there was no discussion.
Yeah, I think what we are asking for, and well, the basis of our interest rate is on Mexico and Pemex's borrowing costs. And what I was explaining was, when you take that rate and you look at a post-award interest rate, there's a different evaluation that you should look at that differently, because we have put forth a conservative rate. It's a conservative rate based on their borrowing costs, but that opens us up to further torment if they can go out into the market and they can borrow money at a cheaper rate than what we are getting on our award. It opens us up to delay. And I also mentioned their actions in this arbitration, which I think should be taken into account when you're looking at the interest rate, not for any punitive measures, but for protection. Because we're going to need protection that this award will be paid, and it will be paid in a timely manner. And if they can go out into the market and they can get money cheaper than what their interest rate is on the post-award interest rate, it opens us up to being vulnerable to that further torment.
Then do you equate post-award interest with moratory interests?
Yes.
Okay, this in fact was the next question, so it's good.
If I may, may I just
sorry,
just to clarify, because we didn't address. I apologize. We didn't address the interest rate. It's our position that post-award interest that is based on Mexico's activity in the merits of the case is punitive.
Georgia, where am I? Yesterday, I think Mr. Melsheimer said that he could not understand how you passed from 73,000 to 42,000. So my question is more for the respondent. Could you remind us or explain how you passed from these two symbolic figures when you read your written explanations?
Just one moment. Our understanding is that the 809 contractors proposed a rate of 73,000, and there's a document in the record that lists what that 73,000 is based on. There were negotiations between the 809 contractors and Pemex. That's our understanding. And after those negotiations, the amount was reduced because certain costs, Pemex did not agree to cover certain costs, And as we explained, the Pemex did not agree to pay for certain days, certain groups of time that the 809 contractors had requested in a daily rate.
You said certain costs, certain. Is there any track of these, any explanation for these certain costs, certain damages?
Gracias, Profesor Pelé. Como
Thank you, Professor Pelé. As my colleague mentioned, once the negotiation took place between Pemex and the 809 contractors, the key factor was that the contractors for the 809 contract showed evidence of the costs they had incurred. They submitted evidence to support their claims. And quickly looking with my team, there's an exhibit R201 that shows the deliberations that took place by PEP and by the contractors. And we can elaborate more on this, but that difference, that change in the rate is the result of that negotiation, but mainly it is the outcome of that evidence being submitted by the contractors. And this is a situation that is different from the situation with the 821 contractors.
Tell you what actually happened based on the documents you have. The contractor, the 809, and let's just keep in mind, the 809 contractor is drilling wells in the exact same area that we were drilling wells. So I just want to have the background. The contractor, and you have it, sent a list. Didn't submit cost, didn't submit evidence. I keep hearing this. The contractor submitted just a list. Went, I don't know, maybe Excel spreadsheet, and wrote some numbers down. Mr. Marfield, who I asked to come and testify, lost that fight. He also prepared a list independently of the 809 contractor. And interestingly enough, they both came up with the same $73,000 number. I don't know what happened between the time they both separately came up with $73,000 and ended up with $42,000. That was the gist of your question. What happened between the $73,000 and the $42,000? Maybe I didn't make my point clearly enough when we had our conference a couple of weeks ago asking for Mr. Marfield to testify. He knows the answer to this.
Solo para agregar un poco.
Just to add a comment, Professor Pelé, the claimants, on the one hand, said there's no evidence, but 10 seconds later, they agree that there was evidence, that there were lists that were created. They think there's an Excel spreadsheet, etc. These are not contemporary witnesses that the claimant want of what happened under contract 809. What we do have is a document that is contemporary evidence, which is R201, which shows the negotiations that took place between Pemex and the 809 contractors to determine what costs were incurred. And at the end of the day, the key point here is that due to force majeure, which we discussed yesterday, and as a result of that negotiation and the evidence submitted by the contractor during those deliberations with PEP, the conclusion was that the two cases are not comparable. It's not comparable to contract 821, and that should be clear.
Professor Pelé, sí, o sea, para
Professor Pelé, just to make it clearer, I would like to be specific, mentioning that C-184 shows the list of the items that were finally paid and that were part of the list referred to by claimants, but this document is supposed to be properly supported. If you wish, we can show it or we can address it later on. And for this to be interpreted in connection with your question, there is a paragraph on page 1 that mentions that there was an unexpected item that was reconciled among the contractors of 809 and Pemex. And based on the information that was provided and also the correct line items for supplies, machinery, equipment, and also indirect costs, and here specifically it says that they are duly integrated and supported, so that this amount was accepted by Pemex. But this is not a list, as claimants mentions, just a page with items that are randomly described. This is an analysis, a study, an assessment of what had to be paid based on what was used, based on the contract itself that was duly supported, and that it was also based on a reconciliation among the parties because of an item that was not agreed.
I have moved heaven and earth to try to get documents out of the government of Mexico. And I just heard opposing counsel testify now about documents that supposedly an 809 contractor submitted. Where are those documents? All that we have in evidence are things that we had to procure, not them. I had to go to a transparency request, and all that is in evidence. And we can have testimony from lawyers till the cows come home. But all we have in evidence is a spreadsheet or a list that some contractor made. I wasn't there. They have the ability to bring somebody, or had the ability to bring somebody from Pemex. Suspect he would have confirmed everything that I'm telling you now. That contractor submitted a list to Pemex. It said, we think we're owed $73,000 a day. What also the evidence, not testimony, the evidence shows you. Independently, Pemex came up with its own list. No work being done. We don't need to prove cost. Zero work being done by the 809 contractor. Pemex, Mr. Marfield, Pemex came up with its own list of what it thought the cost was, or the expense cost was worth for not using the rig. It's not shocking that they both came up with a $73,000 number. But your question, which is continuing to be avoided, how did the two sides for the 809 contractor and Mr. Marfield, Pemex, go from 73 to 42? And as Mr. Sterneman asked during my opening, when you do the math and total all the numbers up that were paid to the 809 contractor, the gap, this payment, it reaches the minimum amount of the 809 contract. This is not hard.
Profesor President, si me permite, solo quisiera...
Professor Pele, I'd like to clarify something here. Counsel for claimant, counsel for respondent is not making any statements. We just provided a portion of an exhibit that was presented by claimants, and that clearly refers to the fact that this list contained or included evidentiary information that supported the contents of that list. Now, we should remember that this is a case on damages, and it is for the claimants to prove the damages cost. We should not prove the damages that were considered for the 809 contractors.
I wanted to ask a question on the inferences the tribunal could draw from this kind of deadlock, apparently. I suppose it is for the tribunal to evaluate. So on that, I have no more question. I have a last one, which is also a bit general. I hope you don't need too much time to answer it now, but you have a lot of time to think about it. None of you, I think, if I am right, having reread all the file before coming, none of you discuss the issue of dies a quo and dies ad quem for the damages. From when do you request damages? Until when should we pronounce ourselves? This is a bit linked to what you discussed rather lengthily at length yesterday on the president's question on Dorama, etc. This is, of course, for both parties. Again, you can reserve your answer for your written.
Well, I'm glad you raise it. We obviously take the position that we're entitled to damages starting from the earliest breach. That's where our claims start. That's where our damages start. And I'm glad you mentioned, because I think a lot, and I thought a lot this morning about Mr. Conte's comment and concern about the Dorama bond and the respect being paid to the tribunal's decision. I thought of another way to maybe address in the interim period in order to preserve your, maybe it might be that we need to submit to you another application for interim measures. I think we're now squarely within those parameters of needing some protection between now and the time that you issue your award. So I think we might be in that clear fairway now where you all have decided that it was a breach to make a claim on the Dorama bond. We all heard yesterday that there's no effort to cease and desist and respect your order. For whatever reason, whether Mexican courts have to respect it or not, I don't want to get into that, but it might be that we need to make that application, and perhaps you all consider the merits of that application, and perhaps a relief on that is during the interim between now and whenever you issue the award, after the post-hearing briefs, reviewing the transcripts, all of that. Because there's going to be some time now between here and the award. Maybe the government of Mexico needs to put up a bond to make sure that nothing happens while you're deliberating, while you're drafting your award, in order to protect the claimants. So I'm glad you raised the question, but to go back, because I appreciate I went a little off, our damages are assessed as of the date of the first breach that you determined. That's back in March 2018? Yeah, March 26, 2018.
We will certainly address this in our post-hearing briefs, but we did explain yesterday that the first day that the government of Mexico became liable was November 10th, 2021, because that is the date when you found that the signing of the unilateral finiquito was attributable to Mexico. So my understanding of you mentioned the dies a quo, and my understanding is that's the beginning of damages, and our position is that is when damages begin. That's when we think that a settlement in a but-for world would have been paid to claimants.
Eso, Professor Pelé, yeah.
Professor Pelé, and also adding to, as we said yesterday, that some of the claims presented in this case have not materialized and they are not compensable. So we also reserve the right to answer the hypothetical request for provisional measures, also stating that there is Article 1134 under Chapter 11 that has to be duly analyzed by claimant.
We never ask question to embarrass any party. I just want to understand. Thank you very much.
Well, thank you, Alan. Well, taking this opportunity, and to the extent that this might be a critical issue in this arbitration, I now ask for your understanding, because I'm going to ask a question as a follow-up to the comment on document C-184. Because if we go back to document C-184, either in Spanish or English, it's clear in that document that the 42,000 was something extraordinary and not foreseen in the contract. And actually, in the table on page 3, line item 223 is something which was not foreseen in the contract. And that price is declared an extraordinary unit price. And my question is, if that was a non-recoverable cost and the contract foresaw non-recoverable costs, why was this not included in the contract? So this was extraordinary and unforeseen. And actually, when the response on the first page of Mr. The Administración and Services Corporate Director responds to the memo from the operational guys dealing with the contract, they make it clear at the very end. Finally, it's important to note that the authorization of items not comprised in the original catalog is the responsibility of the project management area in accordance with that. So I've been a civil servant and I know what this sort of paragraphs mean is, well, I'm not responsible for this. It's your responsibility to determine that 42,000 euros. That's extraordinary, and if you say so, fine, but don't ask for my endorsement of that price, because it's you who are supposed to consider and approve that extraordinary unitary price, which was not foreseen in the contract. And again, the question is, why was that concept not foreseen in the contract?
Señor Presidente, no quiero especular.
Mr. President, I do not want to speculate, and I think that we need a little bit more time to analyze this situation, but I would like to state clearly that what we understand is that most likely is that one of the items was the one that was not provided for under the contract out of the ones mentioned in C184 that complete this list of elements that summed up 42, the daily rate of $42,000. But this is part of the contract. As a matter of fact, 809 establishes how the non-recoverable costs were going to be determined. And as a matter of fact, these costs, let's say the amount that is used in this list comes from one of the exhibits, one of the attachments under the contract, and that is DE2. DE2.
Probablemente un concepto. Quisiéramos.
It could be one of the items. We'd like to further look into this situation to see what is it that it was not provided for under the contract, but this is not the complete list. It could be one element, and we can go into further details later on so that it is clearer to everyone.
I think this is an important issue, and I will insist on that. The question is, I got the impression reading that document that Zapatero, Integrador y Zapata never provided invoices amounting to 42,000. It was just a calculation, as is apparent. You say items, X dollars per day works out to, and you arrive at a figure. But no invoices were provided by Integrador y Zapata underpinning those specific 42,000. It was just a theoretical calculation of unit price times days, and that's the result.
Sobre este punto también queríamos un poco.
In connection with this, we'd like to have a little bit more time to analyze it, but the only issue here is that the document itself, C184 on the first page, paragraph 2, literally states, and here I quote, that they're duly included and supported. So this is not a random list. This is a list based on the contract items, and it is a clear difference, and this is a list that is duly integrated and supported.
That were backed by invoices. It was just a calculation in which the concept was identified and multiplied by the number of days, and that can be construed as soportadas. Or you mean that by soportadas means that there were invoices behind every single dollar of the $42,000 as has a extraordinary unit price?
Señor presidente, creo que esa respuesta desafortunadamente no se la podría dar porque no estuvimos presentes en la elaboración de este documento.
Mr. President, I don't think I can offer you that answer right now, unfortunately, because personally, I was not there when this document was drafted, but clearly the reference to support it means that this is not a random document or an unsupported document.
Complicated. Again, they came up with a number. You're right. This wasn't foreseen in the contract, in the 809 contract. It wasn't foreseen in any of the contracts because the concept of these contracts, to go back to Mr. Pillai's question, was an open contract. The contract had a minimum amount. The 809 contract had a minimum amount. And your question, Mr. Conti, is very in line with something that Mexico showed you yesterday. And I had to summon this up. This is slide 91. In the question and answer session, Mr. Shaw showed you, and if you look at the bottom graphic from the Q&A, and if you recall, I'll paraphrase that clearly. The contract, it confirmed Mexico's notion that these contracts didn't have a firm minimum amount because Pemex had explained that it wasn't going to pay for wait times in between when they were not generating work. Well, why did Pemex respond that way? It can't be lost on us that again, I showed you all the open contracts and the other answers. The reason why they're not paying for wait times and the reason why they had to make up a number for the 809 contract is because they were going to pay the minimum amount. It didn't matter if they didn't ask for the work.
Could somebody translate for me the PEP no pagará por tiempos? The footnote you were mentioning.
I think it would be safe. I'm not a I'm not a native Spanish speaker. I think it would be safer for someone in native Spanish to read it, have the interpreters interpret it, and I'll go with their interpretation.
Now as for interpreter, translate, PEP no pagará por tiempos de...
So PEP will not be paying for waiting times and expenses to be generated as a result of the waiting times.
Bid round, questions and answers is C0229.
And again, the reason why I mentioned that is it is the exact same issue that they were dealing with the 809 contract, and it's the reason why they had to come up with the DE2 adicional. The contracts didn't contemplate this. The contracts contemplated Pemex paying the minimum amount.
May I? Mr.
The interpreters, could you interpret? Otherwise, I could do it on my own in very broken English, which is...
We did it already, sir, when you read it.
Time.
We had a interpretation.
Okay.
Otherwise, I would have protested.
Okay, and now I move, and again we remain on our contract 809, and well, my first question is exactly this one. I take it, and respondent has stated clearly so in paragraph.
May I just respond?
Sure.
Sorry, we were discussing. The question and answer that we discussed yesterday and the one that was just read was specifically for, I believe, packets 1 through 5 not for contract 809. That was a different pack. So the questions and answers are specific to certain packets. That we told you yesterday that claimants only showed you 18 pages, and if you zoom out, you'll see that those questions and answers are grouped by packet, right? So if you start scrolling, you'll see questions and answers for pack 1, questions and answers for pack 2, and pages of questions specific to those packs. The one that we were just discussing is specific to packets 1 through 5, not the 809 contract. Thank you.
But no, I was just saying, my first comment is that you state in paragraph 45 of your response, of the contestación, that in the finiquito of the 809 contract, waiting times between orders were not remunerated by Pemex. And I think that's pretty clear from the acta circunstanciada and the calculations. So only the official periods of suspension, which were used in contract 809 as opposed to contract 821, in which there were no official suspensions, all were de facto suspensions, whereas in the 809 contract there were official suspensions recorded in the system, and only those official suspensions were part of the days paid by Pemex. That's pretty clear. And then as to the term of the contract, I was intrigued by one question which yesterday I failed to mention, but which it's a difference between the two contracts. Because if you go to, this is document in English, R99, and you go to chapter 12, which is page 8 of the PDF, it makes clear that at some point Pemex asked Integradora y Zapata to extend the term of the contract beyond December 31st, 2013. But it was the contractors who opposed that extension, and that's why later on Pemex didn't want to pay any days for 2014, because the contract had been concluded in 31st December 2013, and the contractor had not been willing to extend beyond that date. So in this particular case, I was just to check that was a difference. In this particular case, Pemex offered, Zapatero is a former prime minister, my apologies, Spain, Integradora y Zapata offered to extend the contract, the term of the contract 809, whereas in the case of 821, that was never the case. So that's a difference. Am I wrong in drawing that conclusion from the top of page 8 of document R99?
We're going to defer on that, and we'll follow up. But we do know that contract 821 was not extended.
829, 821, yes.
Yeah, contract 821 was not extended.
But here it makes clear that in the other case, 809, Pemex itself asked for an extension, and it was the contractor who refused to extend the contract beyond December 31st. That's my understanding, and if my understanding is wrong, I would like you to correct me, because from that paragraph I draw the conclusion that it was Pemex who wanted to extend the contract, but the contractor refused to do so.
Sujeto a ver los documentos, señor presidente. Voy a ir un paso a la vez.
Now we're going to go take it step at a time. 809, that is on the record as exhibit R98, is part of what we called packet 6, And this is in the main page of that, on the main page of that document. Now, when we had this negotiation in the finiquito between PEP and the contractors of 809, Zapata, and Integradora IPEC and PEP discussed the concepts to get to that amicable composition. Now, something that we see in connection with the finiquito is that there is a discussion about the potential extension of the contract. Agreed? But that is a power that clearly the two parties to the negotiation could discuss. And that goes hand in hand with what my colleague Gary Shaw explained yesterday, meaning that the administrative court could in no way force PEP to order an extension of a contract. This is a very good example of the fact that this is a power between two parties that they can negotiate this under in a situation of equal terms. So we'll go back to discussing whether 809 had an extension or not, but the same thing that we see here with the finiquito and also 684, all of those elements come here to show us that they are not comparable, that these contracts are not comparable, and in particular from the very beginning, they're different packets. We need to recall that 821 is packet 5 and 809 is packet 6. And page 1 of 809 clearly states so. So we do not understand why this is not something that claimant has understood to date. Just to clarify.
Correctly, when you were referring to page 2, well, C229, the Q&A, I understand from your slide that this Q&A related to package 5, which we know per the contract is 821, right? Or because I heard you saying it's not package 5. It doesn't refer to package 5. But I read it is.
The two questions and answers that we highlighted on our slide from yesterday, which I believe you're looking at,
yes.
Maybe slide 91, those do relate to packet 5, which is contract 821. Yeah. Yes. But our point today was not to 809.
I understand that
yes.
point. That Ms. Bonfiglio said that. Yeah, I understand.
Well, I think now the tribunal is done with its questions. So unless there are any comments, we can continue with the hearing, and we ask Mr.
Would now be a good time to take a restroom break?
I would endorse
okay,
that.
but a short one. Huh?
It's a very 5 minutes is fine.
5 minutes, just 5 minutes. Good morning, Mr. Finley, and welcome back. To the extent that now you are appearing as witness, would you mind, as a first step, reading out the statement that you have in front of you, that you are going to tell us the truth and nothing but the truth and all that?
There we go. I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Many thanks. Then I give the floor for 10 minutes of claimant.
Good morning, Mr. Finley.
Good morning.
Nice to see you here. Before you, you have your 3 witness statements. Do you see them?
Yes, I do.
There's no markings on those?
I haven't checked them, but they appear to be unmarked.
Thank you. If you have reason to refer to the witness statements during the course of this examination, feel free to do that. We have, as the chair just advised, a very brief period of time for you to share a few comments with the tribunal. You were here yesterday for the opening presentations?
Yes, I was.
Yes. Is there anything that occurred yesterday that you feel helpful to share with the tribunal? Your observations on what transpired yesterday.
Yeah, sure. I guess the biggest concern of mine is the reality of the Durama bond, and the reality of now I know about $9 million as well, and the reality of that. And the concern about Finley Resources, which is my career, my company, my life, our ability to obtain bonds in the U.S., obtain bonds with our tribal counterparts in Utah.
I'm very sorry to interrupt, but I have to note that this is not testimony that was in Mr. Finley's witness statement. And normally direct testimony is not used to provide new evidence. Mr. Finley did speak about the Durama bond. Now he's going to be talking about new issues. He didn't speak about perceived difficulties in getting bonds in the United States. That's not in the witness statement. And I have to add, we raised issues about this in our counter memorial. Mr. Finley did not present additional testimony in the reply, so they've been saving this just to bring it on us now. So we do need to object.
Yes, I think it's fair to say that in this direct examination, witness has to concentrate on comments on his statement. Later on, who knows what the tribunal will ask. But for the time being, you need to concentrate on your testimony, your written declaration.
Mr. Finley, could you look at paragraph 21 of your 3rd witness statement? Let me just read it for the record. It says, adding insult to injury, Pemex continues its pursuit of the USD $41.8 million Durama bond and has reserved the right to claim more amounts against us under its unilateral finiquito. All this needs to end. But what did you mean it needs to end? What did you mean when you say all this needs to end?
So what I meant by that is what I'm expressing now is that we have to get on with Finley Resource business, and in order to do that, I need to have finality of the claim of the Durama bond, so I'm assured that I can get additional bonds, additional credit as we continue to conduct business. And I'm worried what's going to come next.
Thank you. In your witness statement, you make reference to the benefits that Mexico received as a consequence of the work that Finley Resource and Prize Permanente provided. What did you mean by the benefits that Mexico received?
Yes. So under the 821 contract, we drilled 27 wells, we being the parties to the 821 contract, of which Finley Resources was a party. And those wells, from the information I received from the field at the time, because we're all excited when a well gets drilled, we know what production's going to be. I estimated that the production's about 200 barrels a day per well when they started. They're probably down to 100 barrels a day decline. And so maybe the average of 100 barrels a day for 10 years or more, 365 days a year. If you use $60 a barrel and you do that math, it's easily around $600 million of value that Pemex has received from the work that we have done, and we haven't been paid for all that work.
Thank you. No further questions.
Many thanks for your questions. Now is the turn for...
Good morning, Mr. Finley. We've met before, of course.
Good morning, Mr. Becker. Yes, we have.
All right. Thank you for being here. We appreciate it. Just following up on one of the comments you just made, for the 27 wells that were drilled, drilled, those payments were made by Pemex, weren't they?
Yeah, Pemex has paid us $48 million on the 821 contract. Not everything that's owed, but some of it, certainly.
But they paid you for the wells that you drilled.
Right. And we took all that money and reinvested it in the 821 contract. We didn't take any distributions or money outside of the operations of the contract.
Okay. And the payments weren't based on how much oil the wells were projected to produce over the following years, were they?
No.
Mr. Finley, I'm going to briefly review with you some issues we discussed during your prior testimony, during the first hearing on jurisdiction and liability. We're going to go to the transcript of day 2 at page 323. Anyway, I just wanted to re-clarify that you previously told us that you're not fluent in Spanish, correct?
I'm not fluent in Spanish, correct. Or I don't read Spanish as well, so.
Fair enough. Let's go to page 289. And this is where you told me that you didn't read the Pemex contracts before they were signed, correct?
Let me read what I said. Right, correct. I didn't read them. They were in Spanish.
Right. And you also told us that you were not personally involved with the day-to-day business of carrying out 821, including communications with Pemex about the work orders. Do you remember that?
Yes, I do. I don't know that it's here, but I remember that.
Good. Thank you. And if we go to page 293, that's okay. You also confirmed that Drake Mesa LLC is an American Wyoming entity and that it's not owned by Finley Resources, right?
Yes, that's my recollection, but I'd like to at least read what I said.
Okay. Let's go to 295. So do we say here, said if we look at
Are you going to give him the opportunity to read it?
Sure. He's been answering questions because he remembered himself, but I'm just pulling him to it now.
Good. Thank you.
Yeah. So this is line 18?
No, it starts at 12. So I put up to you the information about Finley Resources and the company, and I said Finley Resources, Inc. did not own Drake Mesa LLC, did it? You agreed it's not on your consolidated financial statements, right?
Yeah, the companies in the consolidated financial statement were consolidated for purposes of a loan.
Understood.
And so MWS wasn't included in that. But I'm not seeing anything here about Drake Mesa. Oh, there it is. Yes, Drake Mesa was not owned by Finley Resources at the time, correct?
No, thank you. And do you recall the entity Drake Finley LLC, the Texas entity that you had previously and then later dissolved?
Help me out. I think there's Drake Finley.
Yeah.
Was a Texas corporation.
I think, yes, exactly.
And then Drake Mesa was a Wyoming corporation. And we started with Drake Finley, and then later moved our transactions to Wyoming for avoidance of sales tax and franchise tax primarily.
Exactly.
I think that's the way that went.
Yes, thank you. And just to be clear, that Drake Finley, the Texas entity, also was not owned by Finley Resources.
I believe that's true.
All right. Let's go back to your third statement. In paragraph 4, maybe we can make it a little bigger. And here you say that your company, Finley Resources, was a named party to the 821 contract.
Mr. Becker, what page are you on?
I'm sorry, it's projected in front of you. It's paragraph 4 of your witness statement.
Yeah, the third witness statement.
Yes.
And number 6?
In paragraph 4.
4. Okay.
So I ask you to focus on the second sentence, where you say, in addition to pursuing drilling rigs and other equipment, we already had equipment in Mexico that we used for our prior 2 contracts with Pemex. Have you found that?
Yes, I see that.
Good. So you say here that, quote unquote, we already had equipment for our prior 2 contracts with Pemex. By we, do you mean Bissell, the Mexican company Bissell?
No. I think just like Mexico said yesterday, when I say me or Finley Resources or whatever, I'm talking about the parties to the contract, and especially from my perspective, Finley Resources.
Right, but would you agree that Finley Resources was not a party to the 803 and 804 contracts?
Oh, I think they were. That's my recollection, but I may be wrong.
All right, we'll go on from there. But do you agree that the Mexican company Bissell was the one involving the 803 and 804 contracts and not Drake Mesa?
I can't recall.
Okay.
Do you want to show him the contracts?
No, that's, his testimony is fine for me. The contracts say what they say.
You're asking the questions.
Exactly. Thank you. All right, let's go to your third statement, paragraph 11.
Yes.
Okay. So you say here, Mexico and its expert argue that the 821 contract was to drill or complete 42 wells. And you say that is not consistent with the actual contract that we agreed to with Pemex. You see that?
I do.
All right. And then in paragraph 13, right? You say you did enter into the 821 contract to drill or complete an average of 1 well per month. There was no understanding of Pemex having a guaranteed number of work orders or a guaranteed number of wells to drill or complete. Did you find that?
I see 13. You mind if I read it?
Of course.
Yes, sir, I've read it.
Thank you. Now, if we've already reviewed, you don't understand Spanish, you didn't read the 821 contract before it was signed, right? You weren't involved in the day-to-day details of carrying out the contracts, and I think we also reviewed that you didn't see the work orders, correct?
Correct.
So this testimony we've just reviewed is based on what other people told you, right?
No, I wouldn't say that. So, although I can't read the contract, I can discern certain parts of it, and I distinctly remember the minimum and maximum, and that was what I based my decision on to enter into and invest in the 821 contract. The minimum as well as the maximum.
Let's go back to the various entities. In paragraph 8 of your statement, and you referred to what you call a visual, what you call an ownership chart that depicts Finley's and Price's ownership and control of the investments. Do you see that? Do you see your statement?
I'm looking at number 8, right?
Yep.
You want me to read it? I
just want you to make comments. Yeah, take your time. And forgive me, I'll try not to speak over him.
Yeah, and me too. Yes, sir, it's talking about the visual.
Okay, so let's go to that visual. It's been submitted as C227.
Mm-hmm.
And as you noted, it was submitted by the claimants with the post-hearing submission in the first phase. So the tribunal's already seen this. But I just want to be clear about what this page means. I see these bending arrows in green that extend from Prize, Finley Resources, and MWS Management to Drake Mesa LLC, the Wyoming company, on the right. You're not suggesting, are you, that Prize, Finley Resources, and MWS owned Drake Mesa, Wyoming, are you?
I think there's another chart that might show the ownership. Mr. Becker, I think this shows the flow of investments and how they ended up in Drake Mesa SDRL.
Right, when you say the flow of investment, what do you mean?
So some equipment came from MWS in South Texas. Finley Resources purchased a lot of equipment in the U.S., and Price had equipment as well, as I understand it, although I'm not that familiar with Price. All of that flowed into Drake Mesa LLC, and then that was transferred to Drake Mesa SDRL.
So you're saying that Prize, Finley Resources, and MWS Management Inc. sold equipment to Drake Mesa LLC?
Transferred equipment.
Is there any record of that? We haven't seen any.
I think you've seen a lot of invoices that we went over last time that were the purchase of equipment by Drake Mesa LLC or the Texas entity. So the equipment was purchased directly, for the most part, by Drake Mesa LLC. However, Finley Resources employees went to Mexico, as well as MWS employees.
All right. Are there any records of those sort of showing those employees going to Mexico?
I think you can talk to Mr. Claiborne about that, but he was one of the employees that went to Mexico.
All right. Very good. Now, this chart doesn't reflect the invoices showing purchases by Mesa Southern Wealth Servicing, Inc., LP, does it?
No, primarily that was in-kind equipment that we already owned.
Mm-hmm. Already owned. All right, thank you. Let's go to paragraph 15 of your statement. And this is where you refer to the email. This is R192, and we're going to pull that up on the screen while you're reviewing the paragraph. Just to
Yes,
see
so I've read paragraph 15.
Okay, let's put up that email. And we're going to, obviously we're going to use the English translation. So as you can see, it was sent by Mario Alejandro Solis Cisniega from the email address msolis@drake.com.mex. And it's being sent to Pemex. And he's discussing there, he mentions that he met with Pemex several days before the email. Do you see that?
That was a lot real quick. I'm trying to read the correspondence names here.
Sure.
Catch up with you.
Okay, take your time.
Okay, thanks, yeah. So this is from Mr. Solis to Mr. Escobar. Copied Mr. Musalem, I guess. And I would like to read it, if that's okay.
Sure. Please read the first paragraph in particular.
Okay. Okay, I've read the first paragraph.
Okay. I was just noting that this is a message from Mr. Solis, and he mentions the fact that he had a meeting a few days before at the offices of the Exploration and Production Contracting Management to discuss the contract. Do you see that?
Yes, I do.
Okay. Mr. Finley, do you deny that Mr. Solis was a representative of Drake Finley, Mexico?
I don't know if he was or he wasn't. That would really be a legal question, I think. I don't know.
But
I certainly didn't authorize him to do anything.
But you know who he is?
I don't.
Okay, so, but does that reflect that he was unauthorized, or just that you weren't involved in the day-to-day operations?
I wasn't involved in the day-to-day operations.
Okay. All right, let's go back to your statement, to paragraph 16. The short paragraph. Please take your time to read it.
Should I read 16 on my witness statement? Is
Yes,
that where we're
please.
going?
Yes.
Okay. Yes, I see that.
So you say that Finley Resources achieved a 20 to 25% return on oil field projects in the United States, correct?
Yeah, at the time, I think that's what I said, yes.
Now, putting aside for the second whether Finley Resources returns in the U.S. are relevant here, do you agree that no information about the profitability of Finley Resources' U.S. drilling operations has been submitted in this arbitration?
I think I understand the question, but please repeat it.
Is there any information about the profitability of Finley Resources, Inc. drilling operations in the United States in the record of this proceeding? Did you submit any documents? Did you have any records showing that profitability?
I wouldn't think so. You have some consolidated financials, but they would be way more than just the drilling operations, so it'd be hard to, I think, segregate those out.
All right. Thank you. Thank you very much, Mr. Finley. I have no more questions.
Redirect, any?
Nothing further to ask.
My colleagues, Alain or Franz? You? I will start with an easy one. It's paragraph 16, the one we have in front of it. And it's a very naive question. When you are talking about rates of return, presumably returns on equity, are they annual or global rates? So that it's 30 to 35% per annum, or just globally for 3 years and a half of the contract?
So Finley Resources has operations in, I believe, 7 states, maybe 5 states today, but at the time, 7 states. And most of our drilling was done in either Texas or Utah. And so all of our operations would be domestic U.S., so not anything outside of that. But can you repeat your question, Sam?
It's a purely mathematical one. Is when you talk about 30 to 35%, you mean an annual return or a global return for a whole investment over the 3.5 years?
Oh, no, I was talking about the net margin on drilling activity. So if we drill a well, then what was our expected rate of return for the life of the well?
In financial terms, that would work out to something close to a return on equity, or how would that compare with your investment, the large investment you claim that Finley, you made in Mexico?
Yeah, so I don't want to expand on my witness statement, but it's kind of interesting because I think what I was referring to at the time was on a drilling operation by Mesa Well Servicing, or Mesa Southern Well Servicing. If we went and drilled a well for another client, or we did a well intervention for another client, then mathematically, if the top line revenues were $100, then the net margin would be $35.
Understood. So it's not a profit ratio, but it's a margin for each individual operation.
Yes, it would be the net.
Which compares to the 10% that the guy from Mesa was suggesting is comparable, directly comparable, your 30 to 35% to the 10% profit margin that official from Mesa communicated to Mr. Solis or whoever communicated to Pemex. Okay.
Yeah, probably so, although the gentleman that wrote this letter wouldn't have had access to our records in Fort Worth. So the final accounting for our operation in Mexico was done in Fort Worth. So all the income and expense, everything from the field would then come to Fort Worth, and then that would be added to our capital costs, our depreciation, our top line administrative costs, all of that to come to our total number. So he was, I think, referring to the field estimate. So he's getting bills from the various vendors, our labor, and the way normally it works in the oil field is in the field, you keep a track of your daily expenses, and then you compare that to what you expect the revenues to be. And I think he was talking about the last 2 or 3 wells.
Okay. Some very global questions about the finances of the project.
Sure.
Because you say that we made a very large investment, and by that you mean an upfront investment which probably consisted of the 22 million for workover rigs, plus the 5.7 million for the drilling rig, plus trucks and machinery and the like.
Yes,
but
sir.
That was upfront.
Yes, sir, that was up front.
Mm-hmm. And subsequently, what were the type of expenditures to incur? Presumably, there were variable costs, operational costs.
Yes, variable costs.
Not investments.
Correct. So that would all include the repairs and maintenance, and the labor would be the primary cost. A yard to store the equipment, trucks and vehicles to transport labor back and forth from operations. We had a medical doctor on staff and all the benefits that were included with the labor. But that would be the general idea of the costs that we would have whether rig was working or not, if that's your question.
Yes. But you said a moment ago that you plow back into the project the profits you were making from drilling rigs.
Yes.
And my question is why? Because if operational costs were supposed to be covered by current revenue, did you make any additional investments, capital investment with the profits you were reinvesting in the project? Or what was the purpose of not sending to the U.S. the profits you were making?
Yeah, I think we were still growing the business. I can't recall a specific decision why we didn't bring money back, except that we weren't getting paid timely by Pemex, and there was no money, free cash to bring back to the U.S. But exactly what that went for, other than we just kept it in the business, I can't say at this right now here.
And then this is my last question. You hear complain about Pemex trying to make a windfall in this project. At the same time, you have just said that probably the amount of upfront investment that you carried out, the whole group, is in the ballpark of 30 million. Mm-hmm. But in this arbitration, you are asking, say, $160 million.
Yes, sir.
If that were granted completely to claimants, wouldn't that imply a significant windfall for the claimants? Because you invested just 30 million. And setting aside, of course, litigation costs, the Dorama bond, and I'm concentrating here on the project as such.
Yes.
You invested 30, and you want to get back 150, 160. Is not that a huge amount compared with your upfront investment?
Yes, sir. So that's a great question. So the way I looked at it up front was Pemex gave us in dollars or pesos in monetary value a minimum and a maximum. So I'm sitting here trying to decide, am I going to make further investment in contract 821 or not? And 821 was a big contract. We had to commit all 10 rigs, all of our equipment, to the contract to be able to satisfy the minimum and the maximum. So the minimum, in my mind, protected our investment that we would have tied up for 3.5 years. Pemex had no obligation to provide work orders, I think, at all, let alone on a timely or rateable basis. So we had to rely on the minimum and the fact that if we didn't get work orders, that's the money that would come back to us. That's how one of the things I looked at in making the investment decision. Pemex incentivized us to bring our equipment, our expertise, and perform work for Pemex, knowing that we were going to get the minimum if no work orders came or not enough came to satisfy the minimum. But also the maximum is important in that overall consideration. So in the event that a work order came and we didn't have the equipment or the people to respond to a work order, then we had penalties. And those penalties, I think, were maybe for at least for drilling, 17,000 per day. So the reason that the maximum is important is we had to have the right amount of equipment, we had to have the right amount of labor, and the right amount of engineering expertise and talent to respond to a work order. And we had to have all of that equipment and labor ready to go 24 hours a day, 7 days a week. So we're spending labor and maintenance and everything on 10 rigs just ready for Pemex to call and ask for work. And the maximum gave us the guideline to know how many rigs we had, how to support the rigs with the right amount of labor so that we could respond 24/7 to the demands that the contract had. Had there not been a maximum, we wouldn't know how to formulate our investment in terms of equipment and labor and everything, but we were paying those costs every day. So the idea that the minimum is a windfall, in my mind, is just not true. It was the incentive to invest in equipment and the incentive to have all the expenses paid for up front, whether we got a work order, and any money to reimburse us for the cost we were paying up front.
Okay, I have just two questions that I'm going to ask to Mr. Kernion and Mr. Claiborne as well. So if you are not certain about the response, feel free not to answer, and I will ask later on.
Certainly.
The first one is about the events in 2016 when you realized that Pemex was not sending any work orders, and you decided, as you said in a previous statement, you were bleeding cash, and as a prudent businessman, you decided to scale down your involvement in the project. And my question is, what was the timeline of that scaling down, and what was the impact on the expenditures you were bearing? Because presumably you cut significant expenses. You not only terminated employees, but I understand that at some point you took equipment back to the U.S. so that you didn't have any longer the 9 workover rigs in place, but there were less. Could you explain us how the equipment evolved during the time, and particularly in the spring of 2016? If you have a clear recollection, otherwise probably Mr. Kenyon or Mr. Claiborne.
Yeah, I think it would be best to ask Sam that question, because I was not involved in the details. But maybe I have 3 recollections of things that happened. We had done some fracking for Pemex, and my recollection was we used a Canadian company called Calfrac, and Pemex hadn't paid us, so we couldn't pay Calfrac. They brought the sand in, and maybe we brought some equipment, they brought some equipment. And so I remember getting on the phone with a chief financial officer in Canada to explain to him the issues we were having. That's about all I remember with that. And then in addition to that, Halliburton hadn't been paid, and so we eventually paid both Calfrac and Halliburton, but Pemex hasn't paid us for those. And I had to sign a personal guarantee with Halliburton to make sure that they got paid before Halliburton went on a location under the 821 contract. So I remember those 2 things, but I don't remember the timing exactly. But it was a lot of stress for sure. And we talked about bringing rigs back. I believe we brought a few rigs back, but maybe 2 or 3, I don't remember. But by the time they got back, they were vandalized. They didn't have any copper. All the ancillary things had been taken off. And so the cost to bring them back and the cost to refurb them to become workable again was higher than buying new equipment. And so we either did that or decided not to do that, but that's my recollection.
Okay, and my question is about the rigs.
Yes, sir.
Because I'm somewhat confused. The contract originally, Pemex actually required 2 drilling rigs.
Yes, sir.
But in the contract, in one of the annexes that you didn't read, but is DT6, document C-146, you offer, because that annex was drawn by the claimants, you offer 7 rigs, Bissell 1, Bissell 2, and 5 Pioneer rigs. My question is, those Pioneer rigs, are those who remain as part of the 10 or 10 workover rigs that you maintain in the project, or are they different from the rigs other than the PMX 801? Because apparently you kept 10 rigs overall, 1 drilling rigs, PMX 801, and then 9 or 10, I don't recall, 9 or 10 workover rigs. Those workover rigs are the original 5 Pioneer rigs that are mentioned in DT6? Are they different?
I don't know
Okay.
But I do know, one thing I do know I can tell you is the definition of a workover rig and a drilling rig is a very gray line. And I started Mesa Well Servicing in 2000. So I've owned as many as 50 rigs, perhaps, in the United States. And a rig can either be optimized to do well interventions or it can be optimized to do drilling. And it has the limitations of the rig itself have to do with the size of the derrick and its what's called the hook load, how much pipe can it pull out, and what is the capacity of the drilling mud pumps to clear the well as you're drilling. And so we have and had the ancillary equipment to optimize one of our rigs to drill wells or to do well intervention. And so I think Mr. Claiborne will say that we've done in the U.S. for sure many wells that we've drilled with the same rigs that we have in the 821 contract that are called workover rigs. And so given the areas that we were in, Chicontepec, and even in the Shallow Burgos area, our rigs had the horsepower and the capability to drill wells just by adding the ancillary equipment to them. And so Pemex agreed with that. We have the contract with the 9 rigs and the one, what's called the drilling rig, which is the one we purchased from C.C. Forbes in Mexico. So it's hard, especially back before the shale revolution, if you will, to distinguish between a drilling rig and a workover rig. It's much clearer today because we're drilling as an industry down 9,000 feet and 2 miles of horizontal lateral. Our rigs cannot do that. But our rigs can drill a shallow 5,000 or 6,000 foot vertical well.
Okay, and this is really my last question. The 9 rigs, other than the PMX 801, were sitting where? In Poza Rica, the Poza Rica yard, just waiting for work orders? Because I've seen that in DTX 6, you mentioned some pioneer works which are still sitting in Texas, not in Mexico. But I suppose that the 9 rigs that you have been referring and claimants have been referring to were rigs located in Mexico in the Poza Rica yard, just waiting for orders, or where were they?
So that's a question that Mr. Claiborne can answer much better. But I do know that our 821 contract was expanded to include additional areas. I think it was Burgos and Altamira and Poza Rica. And I know that we had physical real estate yards there, but exactly where the equipment was at what time, I wouldn't know.
Okay, that's enough. Franz, yes. Probably by now.
In your witness statement, paragraph 4, you say at the end, we committed all this equipment to use for works under the 821 contract. Then
this is number 3?
Yes,
okay.
Your third one. Mm-hmm. That's the last sentence of paragraph 4. And then you say, I recall Pemex inspecting our equipment and agreeing that our equipment complied with Pemex objectives before we conducted any works. Since you say you recall and you have a personal recollection here, can you give me a bit more information why you have that personal recollection and what exactly happened? A bit more detail when you would have seen these people from Pemex, if you recall, what kind of personnel and what did they verify? Just a bit more detail, because apparently that's a personal recollection of yours.
So, yes, sir. So I would travel to Pemex maybe once a month, once every 2 months. I can't recall when I stopped going, but there was a time I stopped going. So I do recall, and I can't tell you if it was 803 or 804, 821 contracts, but I did meet met obviously our employees, but I did meet some PEMEX employees as well, some who were inspectors of our equipment. So I have that recollection.
Do you remember when that would have been?
Yeah, I do not. The other recollection I have is that Mr. Claiborne especially worked for me, so we would talk more than just occasionally about what he was doing, what's going on, and the amount of inspections, not only initially, but seems like every week there was an inspection, and those were the recollections I have of those specific, pretty detailed discussions with Mr. Claiborne, who could elaborate on that as well. And then certainly discussions with Mr. Currion about the same thing.
Okay. Second question is in paragraph 6. You state our investments included items such as drilling rigs, drilling equipment, and related materials like wirelines, drill bits, and fishing. Apologies, yes. So, yes, in the paragraph 6, the last sentence, you say our investments included items such as drilling rigs, drilling equipment, and related materials like wirelines, drill bits, and fishing tools. Then you say we detailed this information in Exhibit C 0148. Perhaps we could just quickly show that exhibit C148, which is the asset list. My question to you is, since you refer to that list, is that a SAP, or how was this list created? That's what I would be interested. Is that SAP? Is that Oracle? How did all this information, where does it come from, and how is it put together on that list?
Yes, sir. So I would have had this list prepared, and I think Mr. Claiborne would have been the guy that would have directed it getting prepared. I assume that this came from our Drake Mesa LLC QuickBooks report, which I would be speculating, but I think we had access in Fort Worth, our accounting folks in Fort Worth. Then our accounting folks in Monterey would also have access to this. But that would be all I'd know about how this list was created.
It would not be a manual. I mean, you would use a system, an information system that is fed with that information, and is fed with information based on some documents, right?
Yes, it would be in QuickBooks, the accounting software QuickBooks. Yep.
Okay, that's all what I have from my side.
Mm-hmm. So, Mr. Finley, is there any redirect question? I don't think so.
No, thank you.
Okay, then, Mr. Finley, many thanks. You can return now to your seat until the end of the hearing if you want, and we call on Mr. Kernion.
We're ready whenever the tribunal is.
Mr. Kernion, welcome back to this hearing. Could you start by reading out the statement you have in front of you?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Many thanks. Then claimants have the floor for 10 minutes.
Thank you, Mr. President. Can you please reintroduce yourself to the tribunal?
Yes, my name is Luis Dansfield Kernion, and I represent Price Permanent Holdings.
And you filed or submitted a third witness statement specifically for this damages hearing, is that correct?
That is correct.
In your third witness statement, do you recall discussing 3 memoranda of understanding?
That is correct.
And are you prepared to walk through those with me?
Well, I was.
So I'll ask you a specific question about them, but are you ready to do that? Can we get this up?
Can we get the ask?
Would it be possible? There we go. Thank you. So this third heading here, Memoranda of Understanding to the 821 contract. I'd like to start with Memoranda of Understanding number 3. Do you remember where that asked claimants to expand the scope of their work to?
Yes, Pemex wanted to increase production in the region Poza Rica, Altamira.
And do you recall when this took effect or when it was signed?
We agreed to mobilize equipment, and we agreed to go August 2014.
And what was required to be relocated? Was there a specific amount of rigs?
Yes, we sent to that region, we sent 3 rigs with all the equipment, the staff, and all the tools necessary to perform the work.
And was there anything unique about the pricing scheme under Memoranda of number 3 that you wish to discuss with the tribunal?
Yes, Pemex officials with our staff agreed on our rate per rig for $5,600.
And is that rate per hour, per day?
Per hour.
Thank you.
Per rig.
Turning to Memoranda number 4, do you remember what region this covered?
Yes, Tampico, Misantla.
And you're from Tampico, is that correct?
That is correct.
Do you recall around when this memoranda took effect?
At the end of 2014.
And how many rigs were envisioned by this memoranda?
We sent 3 rigs as well, with all the equipment and all the attachments and all the tools as well to perform work there.
Moving on to number 5, what region did memoranda of number 5 cover?
The area of Burgos, next to Texas.
And what were the dates of this memorandum, the key dates?
Well, we signed it in April 2015, but we mobilized equipment because the distances, we start mobilizing the equipment at the beginning of 2015.
And how many rigs did memorandum number 5 call for you to move to Burgos?
We sent 2 rigs over there.
Now, last night you and I prepared this map of Mexico. We'll mark this as CD1, and apologies, I was caught off guard in the waiting room, but I will submit this to the opposing counsel and upload this to the box set as well. But can you tell me, Mr. Kernion, what these 3 dots represent?
Yeah. I'm sorry. The dot in the south, Canoas Martinez, is the yard that we use for Chicontepec. The dot in the middle, Ferrocarril, is our yard in Tampico. And the north dot is our yard in Colombia, Nuevo León, Mexico, next to Texas.
And for that middle dot, are Poza Rica, Altamira, and Tampico similar in location?
They're very close, not similar, but the yard we use, because the locations are pretty close, so I will say that the region is the same. So that's why we use the Poza Rica yard, the Tampico yard for Memorandum 3 and Memorandum 4.
And for the tribunal's benefit, could you break down by dot the number of rigs located at each dot?
In Canoas Martinez de la Torre, which is Poza Rica, we have 2. In Tampico yard, we have 3. And Poza Rica, Altamira, we have 3. Tampico Misantla, we have 3. And 2 in Burgos.
And so that middle dot would be, because of the shared yard, 6 rigs, is that correct?
That is correct.
Now, also in your third witness statement, do you recall discussing issues with domestic employment lawsuits?
That is correct.
And you were present yesterday for Mexico's opening presentation, where Mexico questioned the presence of a third-party company known as Fast Export SA. Is that correct?
That is correct.
Can you explain to me what Fast Export SA did for Drake Mesa and claimants?
Excuse me, I think we're straying into the same type of problem here.
Yes, I think questions in this round at least should be addressed to the statement of the witness, not to all things.
So I would point the tribunal to paragraph 11 of Mr. Kernan's third witness statement, which specifically addresses Fast Export SA. Mr. Becker, do you retain your objection?
Go ahead, please.
Mr. Kernan, in paragraph 11 of your third witness statement, you discussed a company known as Fast Export SA. Is that correct?
That is correct.
Can you?
That is correct.
Can you explain to me what Fast Export SA did for Drake Mesa and claimants generally?
Yes, we hired Fast Export for his expertise in human resources. So we use Fast Export to handle the day-to-day issues with our staff, with our employees.
And who is the employer of these employees?
Drake Mesa, Mexico.
Who paid these employees?
Drake Mesa through Fast Export.
And considering we have limited time, I'd like to move on to another category of your witness statement. I believe this is Section 6, beginning at paragraph 37. Do you recall your testimony of the attorney's fees you have engaged in Mexico to pursue and defend against various lawsuits?
That is correct.
For the benefit of the tribunal, can you clear up how these attorneys were and continue to be paid?
This is definitely new testimony. This was an issue raised in our counter memorial. Claimants did not submit an updated witness statement from Mr. Kernian to respond to us. They're doing it now for the first time at the second day of the hearing. We object.
Fair enough. Mr. Kernian, can you explain to us how and why you divvied up the time as seen in paragraph 39 of your third witness statement?
Well, we asked our attorneys at that time. We have a couple of attorneys, as you can see, and we asked them to kind of break down timing of cases that we were, or they were handling at that time. So that's why we came up with that percentage.
That's all the questions I have for you, Mr. Kernian. Thank you.
Many thanks. Now respondent.
Hello, Mr. Kernian. How are you?
Mr. Becker, how are you?
Good. Thank you. Thank you for being here. Mr. Kernian, when we spoke last time during the hearing on jurisdiction and liability, We discussed that you were involved with the company, among other things, with the company Bissell Construcciones in Mexico.
That is correct.
And we discussed that Bissell had a number of contracts with Pemex in the years prior, even prior to the 803 and 804 contracts, right?
That is correct.
And we can go to the transcript if you don't remember this, but do you recall that you previously testified that you hired other people to handle the day-to-day management?
I can't recall that, but if you can show me.
Sure. Let's go to the transcript of day 2 of the prior hearing at page 362. So I asked you about use of the storage sites, and you said, I can't remember if we used, how many yards we used, because we hired people, very skilled people who managed the management operations on a daily basis. It was not part of my duties every day.
Yeah, that is correct.
Can you identify these people that you hired to manage the day-to-day activities?
Can you rephrase the question, please?
These other people that you hired to manage the day-to-day activities, can you identify them to us? Who were they?
In Bissell?
Yeah.
Well, I cannot recall that. That happened years ago. But I have probably 2 still working with us.
Mm-hmm. Do you have, what are their names?
Raúl López Gallegos, Noé Tilano.
Thank you. Now let's go to page 374, 375 of the same transcript. And this is when you told us that you closed the Mexican companies. Right, so you see here, first you said, down at the bottom, you said, what about Bissell? We closed those companies. I repeated the question, scroll down. And then you said they're on hold. And then you said, I didn't close it, they're on hold. I don't know if you understand, I closed the offices. Do you recall that?
Yes, and I told you that they are not closed. Still today, they are suspended.
Suspended, right. What happened to their financial records?
When you put the company in suspension,
Yeah.
nothing happens. There is no financial records, nothing from the past, from since we shut it down since 2016.
But for the records prior to when you shut them down in 2016, what happened to the financial records?
We don't have it anymore because we release all the people. When they canceled the contracts in Pemex, I completely shut down the equipment, re-released the equipment, and the people who was working in accounting and that department, they don't work with me anymore.
But the records themselves, the paper documents, the electronic copies, you had them deleted?
I don't have them in my possession.
Okay. Let's go to page 377 of the transcript. Do you remember I asked you whether Drake Finley, Drake Mesa, and Bissell shared equipment, and you answered that you didn't remember.
Can I see it, please?
Well, it's right here in front of you. See in line 4, it says, do you know who actually owned the equipment among the 3 companies? And you said not exactly. And then I asked you if they had purchase contracts or other...
Okay, I can read it here.
Yeah.
Mm-hmm.
And then I asked you if they had purchase contracts or other listed assets, and you seemed to indicate that they did not, or you didn't know.
At that time, that was my response.
All right, let's go back to your third statement. We're going to go to paragraph 10. So here you said that Drake Mesa purchased a rig for use under the 821 contract. Do you see that?
That is correct.
And you referenced Exhibit C206, right?
Exhibit C026, I can see that exhibit there, yes.
All right, let's go to that exhibit. Sorry, we're having a little technical difficulty. There we go. Sorry. Right. Do you see that this is an agreement between CC Forbes and Drake Mesa LLC, the Wyoming company?
Yes.
So it was not a contract for purchase of the rig by Drake Mesa, Mexico, was it?
Well, the contract says as per Drake Mesa LLC.
Right. Thank you. And Drake Mesa LLC had no corporate relationship with Drake Mesa, Mexico, right?
Well, the ownership umbrella at the end is Finley Resources and Price Permanent Holdings.
Right, but Drake Mesa LLC is an LLC formed in Wyoming, correct?
As I understand.
Right. It's not a subsidiary of Finley Resources, correct?
I don't know how Finley Resources is structured.
Okay. So in your witness statement, though, you were testifying that Drake Mesa purchased the rig. Did you intend to mean Drake Mesa, Mexico, or Drake Mesa, Wyoming?
Still today, Drake Mesa, Mexico, who owns the company, who owns the rig.
I'm sorry, this document, this contract to which you referred, is it a contract for the purchase of the rig by Drake Mesa, Mexico?
No.
Okay.
As I can read here, Drake Mesa LLC signed the contract and transfer the ownership to Drake Mesa, Mexico.
We'll deal with that other issue later, but thank you. Do you see the agreement is signed July 6th, 2013?
Yes.
Do you recall that contract 803 was signed in February 2012 and 804 in March 2013?
I don't have the dates with me, but I believe you.
Okay. Let's go to Exhibit C158, page 654. And here we have a letter from Forbes Energy. It's dated August 12th, 2013. Do you see that?
Yes.
And we'll scroll down a little bit, and we just want to focus on that first sentence, first paragraph. And you see it refers to a purchase agreement and a lease agreement dated in July 6, 2013, with respect to the lease and sale to Drake of two, they call them workover rigs, including rig 109. And it says that on July 24th, 2013, Forbes delivered the first of the two rigs to Drake. Do you see that?
Is it in the? I'm lost a little bit here.
All right, so we just start with the first sentence of the first paragraph.
Okay. July 6, 2013. Yes.
Yeah, they're referring to the lease agreement and the purchase agreement. And they refer to the rigs, two rigs.
Mhm.
And then it says in the beginning of the second sentence that on July 24th, 2013, Forbes delivered the first of the two rigs, 109. Do you see that?
That is correct.
Okay. And then it goes on to say it can't deliver the second rig for now, right?
Yes.
Do you remember that the bidding process for contract 821 was announced in late August 2013, a month after the date of this agreement and the transfer of control of the rig?
I don't have with me when the 821 bidding started.
But you're aware that that Drake Finley, Mexico, and Drake Mesa weren't awarded the contract until February 2014, right?
I believe it was awarded, they call it FIO, in December 13, and we signed the contract in March 2014. Prox.
That's close enough. But you're saying that the rig was purchased for a contract that hadn't yet been announced. Is that right?
But you have to remember that when the bidding process, I don't know when the bidding process started.
Mhm.
You have to have certain type of equipment, certain type of capacity to follow the process and to qualify to be a bidder for the future of any contracts or any biddings from Pemex.
So, but consistent with what you just said, then, that's a big risk you're taking, isn't it?
That's this business is highly risk.
Right, and if the contract had not been awarded, you would have been stuck with a rig, right?
Well, no. Because we have the 803 and 804 contract, I can use that rig to those contracts.
Okay. Well, that brings up a good point. Let's go to paragraph 25 of your statement. And you said here that you included a rig that we labeled the Bissell 1, that was also called the PMX 805. Why was the rig called the Bissell 1?
The Bissell one is the one that we purchased to Forbes.
Right, but if you're saying it was for the 821 contract, Bissell wasn't a party to that contract, was it?
Can you rephrase the question?
Bissell was not a party to the 821 contract, correct?
No, it was just an internal name for the rig.
Right.
But Pemex put the PMX 805 to that rig.
But as you just said, Bissell had the possibility of using the rig. Is that right?
Well, that ended when they canceled the contract 803 and 804.
All right, but at the time you bought it, you had that in mind.
At the time I bought it, 803 and 804 were active at that time.
All right, let's go to paragraph 27 of your statement, farther down on the same page. So here you say, when we executed the 821 contract, we had just executed the finiquitos with Pemex for the 803 contract and the 804 contract. And then you say, as a consequence of these finiquitos, we were able to use existing equipment for works under the 821 contract, right?
Totally true.
So that existing equipment wasn't purchased for the 821 contract, was it?
No, it was for the 803 and 804.
Let's go to paragraph 28, just a little bit down. Here you say, quote unquote, we spent close to 23 million. So when you say we, you mean Drake Mesa, Wyoming, Mesa Southern Well Servicing, and Drake Finley LLC? Is that right?
The owner of that equipment is Drake Mesa, Mexico.
Well, but the question is, who purchased the equipment?
Well,
are there any records from Drake Mesa, Mexico showing that it bought this equipment?
The U.S. companies bought the equipment and transferred the ownership to the Mexican entity.
Have you seen any documents that demonstrate a sale of the equipment to Drake Mesa, Mexico?
It's the importation documents.
No, those are importation documents show that an item has been imported. It's not a sales transaction.
For Mexico, it's a deed.
Are you a customs lawyer? Are you an expert on customs law in Mexico?
No, but every time we sell something in Mexico, like an example, if I sell construction equipment, they don't ask for invoice. They ask for the importation deed, and we endorse that importation deed as an invoice. It has more value than the deed, because you don't know if that equipment could be stolen or something. So the value of the ownership of the equipment is ruled by the importation equipment name. That's the real owner of the equipment.
Okay, let's just clarify again. Mr. Kearney, you're not a Mexican customs lawyer, are you?
No, definitely not,
right,
and I'm glad of that.
Okay. In paragraph 29 of your statement, you cite to a file you call a presentation dated January 2015. which was submitted as Exhibit C10, C210. Do you see your paragraph 29 there? This
29?
paragraph 29, I'm just reading from the first two sentences of the paragraph.
In preparation. Okay.
All right. So let's go to C210. And I guess here you said you don't remember what it was being used for, right?
Well, at that time, not exactly, but overall, I know where the equipment was doing.
All right, let's go to the second slide. And in the second paragraph, if you could follow along with me, it says Mesa Southern Well Servicing, Inc. is a Texas company formed in XXX to service the oil industry in South Texas and New Mexico. It is based out of Jordanton, Texas, and managed by Mike Hines, a ... This seems to be incomplete. So am I correct, this was a draft and not a finished document?
Well, I can remember this document who redacted, but I think it was for a presentation the company did at that time for the blocks.
All right, let's go down to the last slide. This is a list of what it calls existing contracts. So will you agree with me that the three contracts listed here are 803, 804, and 821?
Well, the contract number says something different there. I don't see 803, 804 or the contract number. I don't see 803.
You don't recognize the dollar amounts or the dates?
The dollar amount, as I understand, $48 million is 803. Dollar amount in $55 million is 804, and 821, the last one.
Thank you. But as you've testified, the finiquitos for 803 and 804 were signed by early 2014, a year earlier than this document, right?
Well, I cannot remember when we signed the finiquitos. The finiquitos can take months ahead when they cancel something.
Well, you were just testified earlier, you agreed earlier that since you had signed the finiquitos, you had equipment now that you could use for the new 821 contract, correct?
That is correct, yeah.
Okay.
They were at the yard, yes.
So
but
why-
I don't remember the dates.
So why are these 803 and 804 listed as existing contracts?
I do not understand your question.
If the finiquitos for these two contracts were already signed, why are they listed as existing contracts?
This is an internal document. This is not an official document. This is a presentation.
A presentation internally?
Excuse me?
An internal presentation?
No, for future. This presentation, as I understand it, was Pemex wanted to have companies to provide services or to assign blocks to companies. So it's basically if they have the experience to assign blocks.
Okay, and so you would have submitted this to Pemex in English?
I did not submit this document, and I did not do this presentation.
Okay, thank you. I want to go back to your statement at paragraph 32. So it's just three sentences. You say you've reviewed Pemex's unilateral finiquito for the 821 contract. And then you say in section 3, Pemex lists the work that it requested under the contract, and this section provides a fair estimate of work that Pemex requested from us. Do you see that?
Well, that's what the document says, yes.
Okay, so you agreed that the finiquito was generally accurate in the description of the work requested?
if the finiquito was accurate. What do you mean accurate?
You just said here, up here, you said this section provides a fair estimate of the work that Pemex requested
Well,
from us.
it was a unilateral finiquito. I mean, you have some, of course. I mean, I don't agree with the unilateral finiquito at the beginning, but.
But the estimate of work, you said here you agreed with.
Probably.
Now, Mr. Kernian, we've discussed this before, but there are no records showing that Drake Mesa, Mexico had its own employees that we've seen.
Drake Mesa, Mexico?
Yeah.
Drake Mesa, Mexico, we hired more than 500 people.
But again, there's no record of that, is there?
Unfortunately, the company that we hired, Fast Export, shut down operations years ago.
Okay, so and you didn't have any of your own records?
We just received less than half of the employees, as that's the one that we showed as evidence.
Okay, let's go to that. That's C-197. Let's go all the way to the left. There we go. All right. This is the spreadsheet that we were provided with by the claimants. Do you see any indication of who those companies work for? Or sorry, who those employees work for?
I believe they work for Drake Mesa, Mexico.
But there's nothing on the file that says that, right?
I don't see the name.
Okay, thank you. Now, if we go to the, I guess what's column C, right? That's the start date. That's the date on which the people were hired, correct?
I believe so.
All right, and we can scroll down, but you can see that they're mostly hired in the early January, February, maybe a couple in March of 2013, right?
That is correct.
So again, that's long before contract 821 would have started the following year. So would you agree with me that suggests that these people were hired to work on other projects?
We, as I understand, these people started to work with us in the 803 and 804, but when they cancel the contracts 803 and 804, we transfer our best crew, our best employees to start working in the 821.
So if the 821 contract had not been awarded, you would have had to lay off these people as well, right?
As I recall, it was a very short period of time when they canceled the 803, 804, and we started the 821. And you required to have the best people available to help you to start. Everything was so fast that we required to start working in the 821 right away. So we use same skilled people that we have in the other contracts to work in the 821.
Well, I understand that. Thank you. But my question was, if you had not been successful in getting the 821 contract awarded, you would not have continued to employ these people, would you?
Can you rephrase the question?
If you had not been awarded, if you had not been successful, had not been selected for the contract 821, you still would have had to lay off these people, correct?
Well, that's one of the issues we have, because we sign a contract. When you sign a contract with labor in Mexico, you sign the contract for the entire period of time of the contract. So if you release the people, that's why we face lawsuits, because they requested the entire time of the contract we signed with them.
I understand. But again, if they were hired to work on the 803 and 804 contracts, and when that ended, and assuming you did not get the 821 contract, you still would have had these issues, correct?
To keep the people?
Yes.
We kept the people.
I know that, but if you didn't get the 821 contract, you would have had no need for them, correct?
I really don't understand your point. Can you be more specific?
Okay. I'll move on. Let's go back to your statement. In paragraphs 36 and 37, this is where you're discussing, again, using we, hiring lawyers. Let's talk about the law firm statements you submitted. I think we can take you to the statements, but I think you've seen them before. I'm happy to put them up. I just wanted to save everyone's time. But I think we've been discussed at length that they don't contain any detail, right?
Yeah.
All right. And now I guess I heard in your direct testimony for the first time that you say you went back to some of the law firms and asked them to do the allocations. Is that right?
Can you rephrase the question, please?
In response to a question you got during received earlier, I thought I understood you to say that you had gone back to the law firms and asked them to allocate how much of their invoices were for which work.
The timing, yeah.
Yeah.
Yeah. The percentage of timing, yes.
Did you receive those allocations or estimates of allocations in writing?
No, they were our office in Mexico handled that situation.
So they just called them up and asked them?
Correct.
And they got an oral estimate?
Correct.
And we have there's nothing in writing, correct? There's no document that would indicate that, correct?
I mean, they provide the service to us. I mean, we don't need anything formal. I mean, just phone call and that's it.
All right, let's go to Exhibit C-180. So this is the this is the letter you sent to Durama pledging your interests in several real estate properties in Mexico that you personally own. Is that right?
Correct.
Is Durama executed on any of that collateral?
Not yet, but there's those properties are in guarantee in the Durama bond still today.
Right. But Mr. Kernian, you're personally not a claimant in this arbitration, are you?
Price Permanent Holdings is the one that is in the arbitration.
Right, but Price Permanent didn't provide the collateral, did they?
Price Permanent the companies of Price Permanent Holdings are the guarantors of the Durama bond.
Excuse me? Let's scroll down. Where does it say that?
In the bond. In the bond, you can see Drake Mesa, Drake Finley, and Drake Mesa, Drake Finley, and Finley Resources.
That's the bond. I'm talking about your personal collateral here, the document we have in front of us.
The personal collateral was requested by Durama bond.
Okay.
Personal collateral.
Excellent.
To back the three companies.
Understood. Thank you. And then, Mr. Kernian, what position did Alejandro Solis Cisniega have at Drake Finley, Mexico?
I cannot recall.
You don't remember him at all working there?
I remember him working there, but nothing in a high rank level.
No. Okay. Thank you, Mr. Kearney, and I have no more questions.
Many thanks, Mr. Any redirect?
No redirect, Mr. President. Thank you, Mr. Kearney.
Thank you.
Any question from my colleagues? Franz, please.
Paragraph 24, in the first line, you say the A21 contract required Finlay, Drake Mesa, and Drake Finlay to have sufficient equipment available to comply with Pemex's request for work. In And I just wanted to get a notion from you of your understanding as to what are the requirements under the contract with Pemex. Was your understanding that you were required to own this equipment, or was it that you just needed to have it available in terms of perhaps a lease, in terms of having possibility to use it, etc.? So I just wanted to know what exactly was the requirements of Pemex, and I asked before Mr. Finley that apparently Pemex came also to inspect whether equipment to be used was actually on the ground as had been apparently been stipulated by you and had apparently been required by Pemex. So I would just like to know what you mean by available, and does it mean available that you need to own it, that you need to have actual property, or you need to have it available? And the way you get the commercial or legal way how you make this available is ultimately irrelevant. Or is it relevant?
To own it.
Yeah. Do you need to have ownership? What means available? When you say means available to comply with Pemex's request for work, how do you make equipment available?
Well, first of all, you have to own it. First of all, you have to have all the equipment attached and to have 24/7 the equipment ready to perform work anytime Pemex requests a work order to do it. So we have the entire equipment owned by Drake Mesa ready to perform work, waiting for work orders. And we have all the equipment available according to the contract 821.
So you need to be able to show that you can take it out of a contract and use it in another contract, or that you have control over that equipment by ownership or lease so that you can use that equipment and bring it to the location that you need to have it.
You cannot move to your equipment that is attached to the 821 contract according to the DT6. So the DT6 tells you what type of, what amount of equipment, tools are has to be available 24/7 to perform the work. And also Pemex can the only work that we can subcontract, it was fracking, because at that time only few companies provide that service, just fracking. So that was the only equipment that we subcontract. The rest of the equipment is still owned by Drake Mesa, Mexico.
And how would Pemex monitor or police, well, police is too hard to say, but how would Pemex monitor that you actually had this equipment available? And at which point in time would they do that kind of monitoring or check?
They practically have like 2 areas. One, monitor the equipment, of course. They check the equipment every day, and they also check employees that they need to be technical available with all the courses that they have to be trained and then need to be let's put it, supervised, that they have all the training and the capacity to avoid any accident.
Okay, I understand. That is sort of a monitoring during the contract. My question to you was, at the moment the contract is awarded, would Pemex also make some sort of a check as to whether you had indeed the equipment available?
Say day first.
And how would they
monitor
do that?
Everything. And
and how would they have checked that? How would they have examined that?
The Pemex had that division, SSPA, I believe. I'm not sure, but I believe it's SSAP, and they monitor daily that check.
Okay, thank you. Thank you. Hi, Mr. Edinger. I must say, I am a bit intrigued by the relationship between Drake Mesa and Finley Resources and Finley globally. At paragraph 8 of your testimony, you say that the ownership of the rigs from Drake, oh no, not here, even before. In paragraph, let's start with paragraph 11, I think.
Professor Pillay, is this in his third witness statement or one of the earlier versions?
Maybe I, oh no, I am on the first, and in fact I want to speak of the third one, sorry. So, excuse me, Mr. Paragraph 8, so Drake Mesa and Drake Finley are parties to the 821 contract, but my understanding is that Drake Mesa is not a party to this arbitration. Is this right? Maybe my questions are more for Mr. Claiborne, but...
We've brought claims on behalf of Drake Mesa, Mexico, and Drake Finley.
But it's not the title of this arbitration, so...
A U.S. investor has to bring the claim either on its own behalf or on behalf of Mexican entities that it owns or controls.
Let me understand better. What are the relations between Drake Mesa and Finley? Because when you say, I listen to your exchanges, and I still do not understand when you say we, who is we?
You're talking about Drake Mesa and Drake Finley.
Yeah.
They are owned by Price Permanent Holdings.
They are just owned by the same entity.
They have the control of those two companies.
Who directs whom?
You mean
who gives instructions to the other?
Well, is Price Permanent Holdings. They are companies of Price Permanent Holdings.
And the decision makers are the same?
Yeah, the same.
Or is the same?
It's the same. But I mean, we have our staff down there who make the local decisions, but those companies are owned by Price Permanent Holdings.
Okay,
or controlled by Price Permanent Holdings.
Thank you.
If I may, forgive me just to make sure everyone's clear, because it gets very confusing. There's also a Drake Mesa LLC in the United States and a Drake Finley LLC from Texas, which are different than the companies being discussed here, just to avoid confusion. Thank you.
Mr. Kernion, I'm going to pose to you two different sets of questions. The first one is about the childhood of a contract, and the other group is about the death of the contract, so to speak, in non-very legal terms. And then about the early days of the contracts, and the question is about the risks that were committed to the contract, because in your paragraph 27 and 28, you make reference to the fact that the rigs from Pioneer, the 5 rigs which are described in one of the annex to the contract, which is DT6, as far as I recall, were never purchased, and they were somehow replaced by 9 other rigs, which you referred to in paragraph 31. So could you walk us through that change of terms in which the original rigs envisaged in the contract were replaced by other rigs, in fact?
Yes, of course. We have a commitment at the beginning to purchase those rigs to Pioneer. And then when the 803 and 804 were canceled, we have basically 9 rigs available. And so we use our own equipment, our own tools to perform the 821 contract. So it was not required to purchase extra rigs when we have the yard full of equipment.
So the rigs, the Pioneer rigs mentioned in the annex to the 821 contract were in fact replaced by other rigs that you had available, and which were the 9 rigs you mentioned in your paragraph 31.
That is correct, sir.
Well, then it's clear that out of the 10 rigs, only PMX 805 was active and was performing actual drilling for. And you were shown before a nice map of Mexico, in which, by the way, I learned that the Costa Rica yard was no longer called Costa Rica, yard, but with another confusing name. Could you explain to us where were those 9 rigs sitting? And you say in paragraph 31 that they were idle and unused. So you had bought them, and they were sitting without any use.
At the beginning, when they canceled the contract, everything was concentrated in the Poza Rica yard, which is Canoas Martinez de la Torre. They have thousands of names around the corner. And so we based there at the beginning, and when we signed the memorandums, because Pemex saw the opportunity that we have a lot of equipment available, and they have the necessities to expand the work. So we sent the rigs, 3 rigs to Poza Rica, Altamira, is memorandum number 3. We sent 3 rigs to Tampico, Misantla, and 2 rigs to at the very top at Burgos. So we distribute all our equipment, and I think we add more because at that time we had to buy more truckings and more staff, because from point A to point C it's 2 days traveling. So we display more equipment, and we bought more equipment to perform the way that Pemex wanted.
And was there any cost involved in keeping those, other than opportunity cost, of course, maintenance costs or any type of cost of having those 9 rigs idle sitting somewhere in yards on those 3 locations?
To understand correctly, in the 821 contract?
Yes.
Of course, yeah. We priced for those 3 for the 3 regions $5,600 cost per hour per rig.
Could you repeat? I was referring to maintenance costs, so operational cost deriving from the mere existence of those rigs sitting in the yards.
Oh, yeah, we have maintenance cost because it's part of the contract. It's part of the checklist that we just talked about it. The checklist, they have to be certified every day. They need to be in good shape to perform. And also those rigs were, you have to have all the technical approvals internationally to perform work. So it was part of the daily check.
As frequently as there were daily checks by Pemex of the 9 rigs. So they came to the yards and they realized that they were not being used, but nonetheless they inspected the condition of the rigs.
Every day.
And well, okay. So that was my first set of questions. And now we come to the evolution of the contract, the late days of the contract, so to speak, between early 2016, when you got noises from Pemex that they would be not sending orders any longer. April 2016, you actually lodged your suit against Pemex. August 2017, when the contract was rescinded administratively by Pemex, and then December 2017, which was the contract limit for the end of the contract, according to the end of the execution period, according to the contract. My question is, what was the evolution of the resources and rigs committed by the claimants to the project in that period between early 2016 and late 2017? Why am I asking you this question? Because I'm trying to reconstruct if the parties, Pemex and the claimants, have tried to negotiate years later, say in 2018, about the actual death, so to speak, of the contract. Some people could have said, well, but this contract was terminated, in fact, not in December 2017, which is the reference point for you in seeking damages. You are considering that the contract came to the very end of its term, December 31st, 2017. But you could say, well, but in fact, the contract was already done from sometime in early 2016, when you were advised by Pemex that you would not be receiving orders, and you then you lodged the suit in Mexican courts. And what was the effective, so to speak, the effective day of termination of the contract for practical purposes? Because at the same time, as you or maybe your colleague, Mr. Finley, said, you realized that sometime in early 2016, you were bleeding cash, and you started yourself disengaging from the contract, cutting expenditure, as any prudent business person does. If there's no business, you try to minimize cost, you mitigate your cost. And but then the question is, when did you significantly cut your expenditures in the contract in the period from early 2016 to the end of the theoretical end of the contract in 2017?
To understand your question, is where I located or
Well, actually, we know from the record that you withdrew rigs from and you sent it somewhere in the U.S., probably back to Texas. And to what extent you have until you were reducing your exposure to the contract? And my point is that if you reduce your exposure to the contract, probably in terms of compensation, you should take that into account, because you didn't have 100% exposure until December 31st, 2017, but much earlier, you yourself, out of prudence, just cut down and scale down your involvement in the project.
Well, at that time, when they canceled the contract, they suspended the contract, canceled in 2016. We back to the yard. We sent all the equipment to the yard. We actually the yard's still there. The equipment, most of the equipment is still there. But at the end, we suffer a lot of vandalism, because when they canceled the contract, and we have a lot of issues with that. So the cost that practically we were saving, it was the opposite, because we were facing at that time a lot of claims from vendors, a lot of lawsuits from employees. So yeah, we suffer a lot at that time. And actually the Burgos yard still have the rigs that we sent over there with all the equipment still there. Of course, it's not in good shape; it's practically scrap. Tampico, we still have the rigs right there, and in Costa Rica, we still have some equipment down there as well, still today.
And then in that notional negotiation between Pemex and the claimants, assuming in the counterfactual scenario that we are discussing around this table frequently, in which Pemex decides to cut a deal with the claimants in parallel or similar to the one that Pemex agreed with Integradora y Zapata. So we are assuming in that counterfactual that at some point Pemex decides to agree with you on a settlement in early, say, sometime in 2018. And my point is, at that time, Pemex in all likelihood might say, well, the contract didn't end in December 17. Actually, it was rescinded in August 2017. So don't ask for compensation beyond the rescission date. And probably Pemex might have said, you shouldn't ask for compensation even after some time in 2016, because at that time you were scaling down your commitment, you were disengaging, you were withdrawing resources back, and therefore you are not entitled to any compensation after some date in 2016.
Well, remember that in my, I believe my first witness statement, I recall that Pemex when they shut down, canceled the contract, the 821 in January 2016, the only way to pay us all the standby equipment and all the expenses that we were having at that time according to the contract, it was to file a lawsuit, which we did in April. And that was the agreement that with that, let's put it this way, excuse, we will be reimbursed all our expenses according to the contract and standby and all the little details that the contract says that we could be reimbursed to them.
Well, again, my goal was to try to figure out in a good faith negotiation sometime in 2018 what would have been the effective termination date for the 821 contract agreed upon between Pemex and the claimants, because I'm sure that Pemex would have never accepted December 31st, 2017, because by that time the contract had already been administratively rescinded. So Pemex would say, no, at the latest, the contract was finished in August 2017, and probably earlier, because at that time you already knew that we were not going to send you any orders, and you withdrew back to Texas, and so the contract in fact died much earlier than the rescission date in August 2017.
Well, we never received any communication with Pemex trying to settle or something after 2016. I mean, I wish we had that opportunity as the other Mexican company had. We never had that opportunity, and we had all the rigs and all the equipment still there. And personally, for me, I mean, they're still seeking penalties, and they're still seeking the bonds and everything. That we have that information. So for me personally, we haven't signed any finiquito yet. So.
Sorry, my question was somewhat confusing. I was considering a counterfactual world in which things change in a bad forest scenario, in which, as I said, Pemex, in theory, would have been willing to cut a deal with you similar to the one Pemex agreed with Integradora y Zapata. So that was a hypothetical world, not a real world that you have been facing. So probably I should have not posed to you that very sophisticated question. And I don't know whether my colleagues have anything else to say, any redirects from nobody. So we can stop here, thanking you for your testimony, and then we have a break, a relatively long break, I suppose, for interpreters of, at the very least, 15 or 20 minutes, 15 minutes. It's okay?
Thank you, Mr. President. Thank you, members of the tribunal.
Should we break now for lunch or no?
We'll break for lunch. Okay, that's very clever.
Mr. Claiborne is available.
He's here and can.
1 hour, 1 hour break for lunch. Yes.
He was available. He was sitting in.